Yeah, I can't hear your voice, but there was just a muffling over the line now.
Silence or stand.
Yes, Ms. Finnett.
Thank you, Your Honour. We have representatives of the Kimberley Community Legal Services on the telephone.
Can you hear us?
I can, Your Honour. Thomas Allen speaking.
Thank you, Mr Allen. Is Judy Harrison with you as well?
Yes, I am.
Thank you. And Mr Allen, you're the principal solicitor, and Ms Harrison, you're a solicitor with the Kimberley Community Legal Services. Is that right?
Correct.
Thank you for your submission. I think you've been told that you have about 10 minutes to speak to it. Is that right?
Yes, that's correct.
So I invite you to speak to your submission.
Thank you. We thank the Commissioners for inviting KCLS to speak to our written submissions to the Royal Commission. We acknowledge the work already done and continuing to be done by the Royal Commission, including the publication of the consultation paper on redress. We recognise the particular disadvantage experienced by the Kimberley Community Legal Services clients, both in terms of their historic injustices and the contemporary manifestations of those injustices, including sexual abuse and what may be termed as related abuse. We consider our services is able to assist the Royal Commission discharge term of reference regarding providing justice for survivors through redress, through A, experience to date dealing with West Australian-based redress and reparation schemes, and B, our experiences working with Indigenous clients for whom formal access or formal justice to reparation schemes to date hasn't translated into substantial or access or to substantial equality. Subject to Council assisting and the Commissioners, I had planned to speak to our papers, and then Judy, having significant experience working with these WA-based schemes, may be able to answer any questions that the Commissioners or Council assisting has.
Thank you, Mr Allen.
I'll go through our paper. I'm not sure if the Commissioners have that in front of them.
We do.
As an overarching...
We have your paper, Mr Allen, and we have read it.
Okay, thank you. In terms of the overarching matters in our submissions, and as I alluded to before, we're well placed to reflect on the West Australian schemes, being important schemes that have been recognised in the Commission's work to date, and the failings of those for Indigenous claimants. Again, as an overarching consideration, we see value in addressing redress from a human rights framework. Relevantly, we note the Bringing Them Home report, which noted the then Van Boven principles, which the Commission has recognised, and now they've been translated into international law through the relevant codified nature of those Van Boven principles. As guiding principles to any redress scheme, we consider it imperative that they be fair, that they be transparent, that it have clear and defined processes, that it provide avenues for review in cases where those matters haven't been followed or where perverse outcomes are reached, that there be provision for lawyer-assisted applications. Going to the paper, the consultation paper more specifically, and to Chapter 2, where it was sought a response on what type of scheme may be recommended by the Commission, we've raised several points, and the sum total of those points is that we strongly support a legislated national redress scheme. I also note comparable submissions being made by the Aboriginal Legal Service of Western Australia, and my understanding is they're going to speak to their paper later today. We haven't had a chance to read all the papers. Suffice to say, we've had a chance to read the West Australian Government's response, being only a page, on the nature of a scheme and whether that's to be a national scheme or a state-based scheme. For the reasons that we've written in our papers, we believe a national scheme is best placed, a legislated national scheme is best placed to deliver redress and ensure justice for survivors of sexual abuse. A corollary to that is the West Australian Government continuing to administer the scheme we see as being a real risk facilitation of justice for survivors of sexual abuse, and that's based on our experiences, and we've provided evidence in closed sessions and through our discussion papers and submissions on why the West Australian Government, or why we say the West Australian Government is not best placed to deliver that. Moving to Chapter 4 of the consultation paper, we say that a direct personal response is a valuable element of any redress scheme. And reflecting on our experiences with Western Australia, one aspect that troubles us, or has troubled our clients, is providing full access to personal records. In WA, we'll call them native welfare files for the majority of our clients. Our concern, the inability to provide or to obtain full access to these files, not only hampers the preparation of responses to redress schemes in this state, but also to the commencement of civil action, because insufficient evidential material is unable to be obtained to file and then to sustain an action. One thing that the Royal Commission, through its consultation paper, has addressed on is the idea of collective redress. We say collective redress is an important focus to meet the needs of clients, especially in the Kimberley, as many continue to live communities or in situations where they have ongoing contact with perpetrating agencies, and we cite the example of church-run missions, for which the church is still an integral part in those communities. We also note and we reflect on the low level of applicants from the Kimberley, and collective redress in some part addresses that low level of engagement. The issues of shame, of reluctant individuals, of uncertain and ongoing relationships with perpetrating bodies in our submission all combine to reduce the likelihood of a survivor of sexual abuse in the Kimberley from reporting that either to the police or to the Royal Commission. If redress is addressed collectively, we have some confidence that that will involve and encourage individuals to come forward collectively, and that significant work needs to be done around that, but it is a way of alleviating that barrier. Despite the great efforts of the Royal Commission and other organisations like No More and Anglicare, who has been funded to assist survivors make submissions, either private or public, to the Royal Commission, there has been a low uptake. We're not surprised by that. There's been other schemes, and other schemes have also failed. So the conflating of the Royal Commission with other failed schemes is a highly probable inference to be drawn from the low level of uptake. In regards to counselling and psychological care, being Chapter 5 of the consultation paper, a real strength of the Kimberley and other areas in remote Australia is the existence of Aboriginal controlled health and medical services. We say that the substantial funding of those services would be better placed to meet the needs of survivors than the creation of new layers or existing Medicare, like Medicare Local. They're the services that best know their clients, best know their needs, and are better able to access those clients, and the clients, therefore, to access those services, have their lifelong healthcare needs met. In terms of monetary payments, and perhaps this is the most contentious area of the consultation paper. And throughout our submissions to the Royal Commission, as I said, both publicly and privately, we've called for a high-end monetary payment or an upper cap above what's been published. The reasons for that are twofold. Number one, we say one of the purposes of a monetary payment is to provide a substantial difference in people's lives, and number two is to recognise the high cost of living in the Kimberley. So if a substantial difference in somebody's life is that they're able to be housed, well then that, we submit, reflects on what the cap should be. Now, a $200,000 cap has been published. We understand that's not a recommendation, but an actuarial guide, we say would be insufficient. In saying that, we fully recognise past recommendations, including those made in the Bring Them Home report, that may not have been taken up by governments, but we say that this process, the Royal Commission's process, isn't to reduce the claims. It is to bear, and our role is to bear truthful witness on what monetary payments should be, why they should be, and that it's for another day being the political process, whether that's taken up or not. But we're not going to reduce those claims at this stage. In terms of process and how a redress scheme may look, it's our experience in terms of page 14 of our report that the failure, as I said earlier, informal equality translating to substantial equality for claimants in the Kimberley has been a question of process. For example, the West Australian Redress scheme was only open for a very short amount of time, and often the testimony that we receive is the first Indigenous potential claimant heard of that is when somebody else received payment. They came to our office, said, well, we've got a story that we want to tell, we think that we would be eligible. Unfortunately, our response has been the scheme is closed, and we've been able to agitate and have questions asked in Parliament and write countless submissions. However, the scheme hasn't been reopened.
Mr Allen, can I just ask you to finish up, if you wouldn't mind, because I'm sure the Commissioners have questions for you and your colleague.
Okay. The other aspect being civil litigation, we've made our submissions there. An interim redress, many of our clients are elderly, and we consider that an interim payment would be appropriate, given that people are in need of money now and in need of redress now and may not see the lengthy process out. But those are our submissions.
Thank you very much, Mr Allen.
Mr Allen, I know we've talked about this in the consultation process, but I'd like you just to share your thoughts with this broader community that's firstly present in the room. You understand there's a number of people here, but also there will be many people watching this via the net. You speak of the amount of money. Do those who you are helping in this issue see redress as different to a compensation scheme such as might be provided through a mechanism like common law damages?
As I said, Your Honour, there's a general conflation from our clients' points of view between the several schemes that have been made available and not through common law or the civil courts, because that's not been to date an accessible remedy for clients. In terms of the payments made to date and the cap being reduced from the West Australian redress scheme, effectively halved, there is some knowledge of how much it may look like, but it's not, if I understand Your Honour's question, from the point of view of how much they may get at common law. It's more how much has been available to date and our advice around that, and also around our submissions being made from, as I said, more human rights principles about making redress and what the guiding principles for that should be.
Well, as you know, our task is to make recommendations that might provide justice for victims, as the terms of reference put it, through redress. I'm just interested to know clearly what it is that's driving the expectation of the maximum amount in a redress scheme as those that you're helping see it. It would seem it's an acceptance that it's not common law damages, but what are the drivers of the amount of money?
The drivers being perhaps threefold. The use that that money may have, or the use that a monetary component of redress may have on their lives. The historic disadvantage that the abuse has placed that person at, and it's not uncommon for people in the Kimberley to have worked their whole life, suffered institutional abuse, including sexual abuse, received no education and have no financial support to retire on. That's quite a common factual matrix for clients in the Kimberley. And we interpret providing justice perhaps more broadly than other submissions have been made to the Royal Commission in terms of housing, and have framed our submissions on those sort of financial considerations.
Is it understood that a redress scheme won't, for example, provide what common law damages would do to compensate someone for loss of income? Is that understood?
Yes, that is understood, Your Honour, that any heads of damage that might lead to a substantial settlement at common law, if that were available, that a redress would not match that. That's commonly understood.
Yeah, you appreciate the importance of the issue because in the Commission is seeking to identify what may be just, and then for the institutions and government to take up an appropriate response. It would be unfortunate if expectations couldn't be met because they went beyond what one might consider in a redress framework. Do you understand?
Oh, absolutely, Your Honour. And as I alluded to before, because common law damages haven't generally been available, the expectations of the Kimberley Community Legal Services clients haven't been at that level.
Yeah. Ms. Finnis, do you have any questions?
I do, thank you, Your Honour. You referred in your oral submissions and also in your written submission of the need for some appeal process as part of the redress scheme. How do you see that appeal process working, and what would it be from, and who would conduct it?
Well, we say at all levels of a redress scheme there should be a removal or an impartiality from the processes and from the institutions at whose hands the abuse was suffered. So we would say that any appeal process should still remain independent from the states, and perhaps a legislative body who would oversee the commission of this redress project would also have an appeal mechanism. It may be that there are some perverse outcomes. It might be that that some information isn't considered. In our experience working with the West Australian scheme, sometimes critical dates led to appeals, and if it wasn't for an appeal mechanism, that then injustice would have been done. So it's not perhaps in terms of appealing a monetary amount, but more eligibility and evidential considerations that would lead to an appeal and to a reconsideration of an award, or a decision not to make an award rather than quantum.
So it would be an appeal as to process rather than as to outcome, is that right?
That's right.
And who would the appeal be to, or what institution would the appeal be to?
In the West Australian examples, we appealed directly to the body who are administering the scheme, to the departmental workers. If a legislated scheme were to be enacted, we would recommend that there be an appeals committee or something of that nature, or provision for that to be assembled under that enabling legislation.
So established just for the purposes of this redress scheme?
Well, if I understand your question, it may be that existing mechanisms could be referred to like state administrative tribunals. I guess we don't have too much to say on that other than that there should be a mechanism. If it's going to be cheaper and more palatable for the use of existing merits review schemes, then we would support that.
Thank you. You refer also in your submission to the elements of a direct personal response, including assistance to link up with other survivors nationally and regionally. That's right?
That's right.
Have you thought about any privacy implications of providing that as an element?
To be honest, we haven't considered the privacy elements of Link Hub. Suffice to say that we work regularly and often with existing Link Hub services, the Kimberley Stolen Generations being the most relevant where we are, and there's comparable organisations, they may have amalgamated now in the Northern Territory. We've always provided clients' details on instructions to those organisations, and I haven't had cause to inquire how they manage that internally in terms of privacy considerations. But obviously that is a consideration.
And just finally, can you tell the commissioners what you would say a culturally safe redress scheme would look like?
That's a great question. A culturally safe redress scheme in an environment where previous reparations and redress schemes have we say failed, it is a live issue. Any future scheme may have or may not be immune from breaching cultural sensitivity or cultural protocol merely because of the failure of previous schemes. There's fatigue, there's distrust, and that's been perpetuated, unfortunately. If a scheme recommended by the Royal Commission is to have the best hope of being culturally relevant and appropriate and safe, there are several key elements that we say should be incorporated. The first is the use of promotion, and if I can generally term it as access. The scheme has to be known and understood by those who might access it. One thing that we found from WA-based schemes is that there's been a low level of access, there's been a low level of take-up and just knowledge. So we're talking translated into language, using local media sources like radio stations and non-written communications for people who may be illiterate or don't access mainstream media. It may also be organising it through collected bodies and represented organisations, as we say, or collective redress. That may be a more accessible and a more culturally safe way to go about rolling out a scheme. But perhaps our experience, the most important aspect is time. Messages get around and messages permeate, but it takes time. For example, the clients that come in and say, we've been sitting, we're women, we're old, we've known each other for a long time, one person got it and we didn't because we didn't know about it. That sharing of stories and information and providing the individuals time for them to make informed decisions to then come forward is an important, a key element that would make the scheme culturally safe, and to date hasn't made comparable schemes culturally safe because they're truncated, they're limited by time, they're wrapped up, and then everybody misses out.
Thank you, Mr. Allen.
Thank you, Mr. Allen, and Ms. Harrison. Thank you for your contribution today and your contributions throughout our discussion processes. They, like all of the contributions we receive, are thoughtful and helpful to us in formulating our views. Thank you again.
Thank you.
We thank the Commission for their time.